In this part, we'll be starting with the proposal. So in this previous part, we have seen a quick overview of what is a contract, and we have started the Indian Contract Act 1872, and we've completed until what is a contract, a brief summary. So in this part, we'll be starting with the first step, that is the proposal. So for any contract to arise, the very first thing which should happen is the proposal. So we'll be starting with the proposal. So what is a proposal? So we've already seen in the last part that if a person A has said something to person B, either to do or abstain from doing something, then the particular thing which A has told to B will become the proposal. So if A has told, for example, he has told to B that he wanted to sell a piece of land for a particular price X, and then this particular thing will become a proposal which was sent to B by A. So now we'll be studying about the essential characteristics. The essential characteristics, that is the requirements which a proposal should have. So anything, any statement which is given by a person will not become a proposal. So there are some essential characteristics which a proposal should have. So anything you tell will not become a proposal. There are certain criteria to be followed for anything to become a proposal. So the first criteria, that is the first characteristic for any proposal to become a contract, is that an offer must be intended to give rise to legal consequences. So here you can say the proposal as a offer. So proposal is basically offer which is said by A to B. It is not that they have to do it compulsorily. So it is an offer which A is saying, or he is just expressing his view to B about this particular land. So this will become the offer which is sent to B. So an offer must be intended to give rise to legal consequences. So any offer when A and B have entered into a contract, so if A has sent a proposal to B, then that must be intended to give rise to legal consequences if B will accept that offer. So if there has been a contract in between these two, then that must be enforceable by law. Then only it will become a contract, or else it will become void. So if an offer is intended, that means it is meant to give rise to legal consequences, then it is valid and you can proceed further. So both the parties, both party A and party E, should have the intention of giving rise to legal consequences. Their particular contract should give rise to legal consequences. So for this, let us understand with a proper case. So Rose and Franco versus Crompton and Bros Limited. So they basically, these both had a contract between them in the intention of the sale and the purchase of tissue paper for a certain quantity and a certain agreed price. So these both companies have had a contract between them on the issue of sale and the purchase of this particular item. And when they had a contract, when there was a breach of contract, so something, a point in the contract wasn't followed, so then it will become a breach of contract. Breach in the sense going outside or beyond the contract. So something which they have not agreed to do, but it happened, then it is called the breach of contract. And when the plaintiff has applied or approached the court that there was a breach of contract, then there was an important point to note there that in their contract it was clearly written that it was not based, or it is not giving rise to any legal consequences. So they are, in the contract it was written that they were not intended to give any legal consequences, and also their contract between the two parties was based on the mutual loyalty and friendly cooperation. So they had written in the contract, which was signed by both the parties, that they did not want to give rise to any legal consequences, and it was based, their contract was based on mutual loyalty and friendly cooperations between the two parties. So they were not intended to give rise to any legal consequences in their contract. So it is not enforceable by law, and so they cannot claim the damages. So see, if there is a breach of contract, then the one who has suffered will be given that damages, either the monetary ones or anything like that, to the one who has suffered. But when in the contract it is clearly written that they did not intend to give any legal consequences and it was based on mutual loyalty and friendly cooperation between the two, then this point was not there in that contract, and so it was not even a contract, it was void from the starting itself. Or they were not intending to give rise to any legal consequences, so the court can also not interfere in this matter. Moving on, for the second characteristic of a proposal. For any proposal to become valid, what is the second characteristic? That is, an offer. Proposal must be capable of creating a legal relationship between the parties. So, an offer which is made between both the parties, if the offer which is said by the party must be capable of creating legal relationship between the parties. So, if suppose some gaming apps are banned in a particular place, so if there is a country and in that country the gaming apps with the real money or all of these are banned, and if both A and B, A is saying an offer to B in the basis of the real money apps or anything like that, if that is what their contract is, then that will not create a legal relationship between the parties, because it is illegal to play such games in that particular place. So if there is a contract in between these both people based on such a thing which is not legal in that place, then there won't be any legal relationship between the parties, and therefore they are not capable of either having monetary gains or anything like that, and the court will also not interfere in such matters. So it is important to remember that an offer must be capable of creating a legal relationship between both the parties. So whenever they are entering it an offer, they have to see that it is legally valid to perform such a thing. So let us take an example about an offer which is intended to become a legal relationship between both the parties. So the case is pace. So we can see that this person is the plaintiff and this is the defendant, and let us take this to be as X and this to be as Y. Y is the house owner and X is the lodger, and along with the house owner there is the granddaughter of Y. So both Y and granddaughter of Y and lodger, who is the plaintiff, that is X. So even though X was a lodger in the house of Y, they have almost become like family members, and they used to they used to send their coupons together to a fashion competition that was appearing in the Sunday newspaper. So, in the Sunday newspaper, there used to be some fashion competition, and for that, they used to forecast, that is, say beforehand that something used to happen, and they used to apply the coupons, and the coupons were written by X. The coupons were written by the lodger. Coupons were written by lodger, and they were written in the name of Y. They were written in the name of Y. So all the three, that is the X, the lodger, the house owner, along with the granddaughter of the house owner, these three used to forecast together, and they used to send their responses through the mail, and whenever they wanted to propose their responses, they used to share the money into three parts whenever they wanted to keep the postal charges as well. So whatever the postal charges is there, they used to divide into three parts and send, and both X and Y have made an agreement or a oral saying in between two, that if they win in this competition, the fashion competition, whatever prize they will win, it will be divided into three parts. So this agreement has happened between X and Y, and granddaughter was not present when they had made such an saying. So granddaughter used to assist to the house owner, and the lodger and the house owner and the granddaughter together used to fill up the coupons, and the coupons were written by the lodger in the name of the house owner, and they used to send, and the postal charges were paid by all three of them. It is shared by them informally, and both the lodger and the house owner thought that whatever the price they get will be divided into three and will be shared by all of them. So one fine day, when they truly won the competition, when they have won in the competition, then 750 pounds was given as the price. 750 pounds was given, but the house owner has not given the 250 share of whatever needs to be rightfully given to the lodger. So they have thought that the price will be divided into three parts, and the 1/3 of the 750 will be 250, and that should be rightfully belonging to the lodger. But the house owner has refused to give 250 pounds to him, saying that it was not legally binding. They had not made a legal agreement to what they have said in between these two. And there was a point that whatever the price which they have got for that particular coupon, that coupon was forecasted. That coupon was forecasted by the house owner's granddaughter. So even though all three of them used to send the coupons, but whatever the coupon which has won the prize, that was forecasted by the house owner's granddaughter, and so the house owner has refused to give his share of prize to the lodger. So when the lodger has went for the legal aid in this matter, then they have said that an offer which is intended to create a legal relationship between the parties is valid, and therefore they have said that the 250 pounds should be rightfully given to the lodger. Let us see another one, that is Johns versus Padavattan. So here Mrs. Johns was living in Trinidad, and she has thought that her divorcee daughter who was divorced, who was employed, that is, she was working in the Indian Embassy in Washington. So a divorcee daughter was working in the Indian Embassy in Washington. What did Mrs. Jones do? So Mrs. Jones' divorced daughter was employed in the Indian Embassy in Washington, and that she wanted to become a barrister by studying law in England. And so Mrs. Jones had promised her daughter to pay a monthly allowance, and she also acquired a land in England to enable her daughter to stay and continue her studies. So basically, she has acquired a house for her daughter to live in and also wanted to pay her monthly allowance. So, when there was some quarrel in between Mrs. Jones and her divorcee daughter, then she has approached the court and wanted to move her daughter out of the house which she has given to her daughter. So basically, she has given her daughter this house for her to stay and study law in England. So when there was some quarrel between these both, she has approached the court and she wanted to get the possession of the house. But what did the court say? So the court has told that it was an saying in between the mother and the daughter, which is not intended to create any legal relationship. So when they have thought to take such a thing, like when she thought of giving her the monthly allowance and acquired a house for her, they have not thought of any legal consequences, or it was not intended to create any legal relationship between the both. They are mother and daughter, and there was an arrangement between these both, and it is not legally binding. So there we cannot, the court cannot verdict to say that the possession of the house should go back to Mrs. Jones, because it was a agreement between mother and daughter. So in these two cases, we have seen how in variety it is about the second characteristic of the offer or the proposal. So an offer must be capable of creating legal relationships. In the second case, we have seen that it is not intended to create any legal relationship between the mother and the daughter. So in the first case, we have seen that there was a relationship in between them, and therefore the court has said that he have to be given his share of 250 pounds. So with this, we have completed the second characteristic. Moving on to the third one. Now, studying the third one, that is the terms of the offer must be certain, or at least must be capable of being made certain. So whatever the terms which are in the contract, so whatever we have mentioned in the contract must be certain, in the sense it has to be proper in an understandable and practical manner, and at least must be capable of being made certain. So we can understand this with an example. So in the case Taylor versus Partington, so let me write clearly, Taylor versus Partington. So they have entered into an agreeing to take the house on lease for a period of 3 years. So there was a house which they have agreed to take into lease for a period of 3 years at a rent of 85 pounds per annum. So they had agreed to take the house for 3 years lease with 85 pounds per annum. And there was another point that the lease will be continued provided the house was put into thorough repairs and the drawing rooms Here is the catch. Are handsomely decorated, agreeing to the latest modern style. So, in the agreement between the people, they have said that the house will be taken into lease for a period of 3 years with £85 per annum, provided the house was put into thorough repairs and the drawing rooms are handsomely decorated, agreeing to the latest modern style. So, handsomely decorated and latest modern style. So, you've seen the point that they have to be certain or at least made to be certain. So, when they have added such a thing like to the latest modern style, so how can you say something is modern or something is not modern, or something is properly placed or something is not placed? So, it depends on the perspective with what you look at. So, one person's feelings will be not the same as the other person. So you cannot say that the latest modern style for one person may be the same for the other as well. So when such a thing is included in the contract, it will not become proper, because you cannot say that I will give this £85 only when it is to the latest modern style and handsomely placed, and all these things will not make it a proper contract. So they are not specific on the ground, and the term in question has imported uncertainty. That is, it is not certain that what is not properly clear, and so this particular thing cannot be enforceable by law because the latest modern will vary from person to person. So with this, we have completed the third point as well.